You recall that you filed a declaration very early on in this case in which you you stated that you, quote, testify that the type and amount of mold in the Kramer house could not have caused the life-threatening illnesses that she claimed. Do you recall saying that in a declaration?
This case has been going on for 3 years. No. I'm not saying I didn't, but I need it in front of me.
Do you recall that that is what you testified to when you testified in the case involving Ms. Kramer's claim with her insurance provider?
I'd have to see what was on the declaration, and at this point, now we're talking about a case that was a lot of years ago. I don't remember that specific case hardly at all.
Well, don't you recall that I took your deposition in December of 2007, and in that deposition you said you couldn't remember what testimony you gave in Ms. Kramer's action against her insurance carrier, correct?
So that's exactly the same testimony he just gave. And you are now, admittedly, going over stuff you have already asked the witness about.
Well, now here's why I'm asking. Because in December of 2007, I asked you these questions, and you answered just like you did. You didn't remember anything about it because it was so long ago. And in March of 2008, I get a signed declaration from you in which you say, quote, I testified that the type and amount of mold in the Kramer house could not have caused the life-threatening illnesses that she claimed.
Well, why don't you show us that declaration that you're talking
it's
about?
there. If you want me to go get you the signature page, you'll see that that's one of the things he says there. That's the page that was copied. It starts out, I first learned of defendant Sharon Kramer.
What paragraph?
I don't know. Here, you show me. It says, I first learned of defendant Sharon Kramer in mid-2003.
Okay.
So what I'm asking is, was there something that caused you to remember your testimony in Ms. Kramer's action against her insurance carrier better between December and March of 2008?
At this point, it would have... I don't remember specifically. I think we have produced, if we haven't, we should have, what little case material we've got left from that situation. If we haven't produced that, that was an oversight, but I'm quite certain that we did produce that.
Well, as you sit here today, do you recall if you testified in Ms. Kramer's action against her insurance carrier that the type and amount of mold in the Kramer house could not have caused the life-threatening illnesses that she claimed?
I'd have to go back and look at the record. That would certainly be consistent, but since I don't have the material in front of me, I don't know how much I can say about it.
And weren't you made aware of documents at the time that the lawsuit with Ms. Kramer's insurance carrier was going on? Weren't you shown documents that showed that, in fact, she did not make that claim, that the mold was causing life-threatening diseases?
Could I have that read back, please?
Question, weren't you made aware of documents at the time that the lawsuit with Ms. Kramer's insurance carrier was going on? Weren't you shown documents that showed that in fact she did not make that claim, that the mold caused the life-threatening disease? Sorry. She claimed?
Object as having been asked and answered at the prior session of Dr. Kelman's deposition, and this is beyond the scope of the permitted today's deposition, but I'll permit the witness to answer.
Weren't you provided with documents at the time you were acting as an expert in the case involving Ms. Kramer against her insurance carrier? Weren't you provided with documents that showed that she was not, in fact, claiming a life-threatening illness on the basis of mold in her house?
Same objection. You can answer.
That's absolutely not true. I might have been showed, I think Ms. Kramer has revised the history of her suit. So I may have been shown documents to that effect, but there were other documents claiming extensive injuries.
But don't you recall that Ms. Kramer's daughter had cystic fibrosis?
Yes.
And that the claim was that mold could exacerbate that particular condition.
Objection irrelevant. Has nothing at all to do with this lawsuit, but if the witness has a recollection, you can testify.
To the best of my recollection, the levels of mold spores indoors were equivalent to the levels outdoors. And what I had said was that there was no elevated risk indoors compared to outdoors.
But you said in your declaration the life-threatening illnesses that she claimed. So wasn't it your statement that she was claiming life-threatening illnesses because of her home?
Yes.
But weren't you shown documents at the time you were acting as an expert in that case that in fact she was not making such claims?
There was a set of documents to that effect and a set of documents with all sorts of strange claims.
And do you
that did relate to life-threatening illnesses.
So you remember seeing a document in which you believe it indicated that Ms. Kramer was asserting the house could cause life-threatening illnesses?
Yes.
What document do you think that was?
I don't remember at this point. That was part of the case study.
Do you recall a document that indicated that she believed that the mold in the house caused a life-threatening illness?
Yes.
But you don't remember specifically what that document was?
Not at this point. We're talking about a case that was 8 years ago, 6 years ago. I can't remember.
And is it your belief that your testimony in that case Ms. Kramer had with her insurance carrier is some basis for Ms. Kramer's feelings about you in particular?
Yes.
How is that?
Objection. Vague, ambiguous, incomprehensible. Instruct the witness not to answer. Maybe you could rephrase the question.
Do you believe that she believed that your testimony was adverse to her in her claim with her insurance carrier?
Yes.
Okay. Why?
Why does the witness believe
Why
that
did
she
yes.
believed that?
Yes.
Why does the witness believe that Miss Kramer believes that? Incomprehensible, vague, and ambiguous. If you understand that, you can answer.
Well, she walked out of court with a check for $500,000 and said, "Damn, I'd be really rich if it weren't for that bastard Kelman." Anything like that? Did anything happen that made you go, "Wow, she really hates me because of what I did in this insurance lawsuit"? Anything like that?
Is there any testimony that she walked out of court with $500,000?
Yeah, there's a judge's order to that effect.
Oh, that's that confidential order? That confidential one?
We've
I
already
haven't
talked
seen
about it millions of times in an open court. It was an order approved by Judge Orfield in this case. Were you made aware that she got a judgment, a substantial judgment in that case?
You're aware she got a judgment in that case?
I was aware she got a judgment.